Assalamu alaikum and welcome to the Free Legal Advice Show on British Muslim TV. I am your host, Riffat Hussain. Thank you once again for joining me in this show where I will aim to address any queries that you have in relation to legal matters, a wide variety of issues I can deal with. I beg your pardon, already losing my words. Anything related to English and Welsh law. As always, our viewers will be aware that you can participate in this show in one of two ways. Either by calling direct into the studio, and that's on the landline number that you find at the bottom of your screen. If you are calling live into the studio, please do mute your television or whatever device that you are watching this program on prior to coming live on air. If failure to do so results in an interference with the sound and then prevents me from hearing your query, so please do mute any other devices and speak to me directly through your telephone. If you do wish to participate in the show but do not want to come directly through the studio, then you can send a WhatsApp message again on the number that you find in the bottom at the bottom of your screen. When sending through questions, please provide sufficient detail for me to establish what your inquiry is. Again, please don't identify any individuals, maintain that confidentiality, and be aware of any restrictions in respect of information that you're providing, particularly if there are ongoing legal proceedings or if there are vulnerable individuals. Then present your question in a manner which maintains their confidentiality and their privacy. And again, I will try and provide that guidance to you. If you are asking a question which relates to a matter that's not within English and Welsh law, then I may need to signpost you to alternative services. It's not a jurisdiction that I would practice in and therefore be familiar with. There may be occasions where you present a question and it's not something that's within my knowledge. In those circumstances, I will either signpost you to an organisation that's better suited to assist, or I may take your details to revert back to you in a later show or after the show so that I can provide you with that guidance. So again, please be patient with me if I'm not able to give you an immediate answer when you present that question. As always, I'm going to begin this show by providing you with some legal updates. As many of you know by now, my main area of practice is UK immigration and asylum law, and there has been some developments in relation to this field today. Many of you will be aware of the ongoing legal challenges in respect of the asylum aspect of the work that we do and the actions planned with regards to those. Please do. It's so important that we help the vulnerable individuals seeking protection and sanctuary in this country. And if you are able to contribute to helping them establish safety, then please do so. There's a number of ways that individuals can have their voice heard. There's many petitions. You can write to your MP, and there will be organisations in your local area that has action and means by which you can participate and put your voice to support those vulnerable members of our society. That aside, we do have another update, and it's an update that many of our viewers have asked about, particularly over the course of the last 12 months. And that is in relation to Zambrano carers. For those of you who are unfamiliar with Zambrano carers are those individuals. It's a European right with regards to individuals who care for children and young people, and particularly British citizens and European residents, who, if the parent or the adult responsible for them was to be removed from either the United Kingdom or the European Union, would then be forced to leave with that parent, for example, because of their age or because there's nobody else available to care for them so that they can remain in this country. And what we had was there was case law around this, in which there were certain aspects of the Secretary of State's policy which were found to be unlawful. And the Secretary of State agreed to review her policies around this issue. they have been delayed. I believe the policy was initially expected sometime in March or early April, and that was put back. And then the second deadline was pushed back as well. But we do, as of today, have that policy. And it's a welcome policy because it does now recognise the right for those individuals who are primary carers of such children to be able to apply for either pre-settled or settled status under the Appendix EU of the immigration rules. Now, Appendix EU is the appendix that was introduced to replace the European regulations, which predated our exit from the European Union. And so these are now the rules that govern those individuals who are entitled to residence because they were here at the right cut-off dates or had been residing here at those dates. Now, with regards to Zambrano carers, the issue here is this, that an individual who is able to apply as a Zambrano carer can now do so. Previously, the Home Office had refused these applications, either for those individuals who already had leave to remain under the immigration rules, so mainly individuals who were on the 10-year route to settlement, or who could realistically apply under the immigration rules, and therefore the Home Office view was that those individuals cannot apply under the Zambrano Appendix EU sections because they had an alternative available, which meant that the child would not then reasonably be required to leave the United Kingdom. A slight concession there from the Secretary of State, now accepting that those applications can be made. The difference between pre-settled and settled status is that an individual who has resided in the United Kingdom for less than 5 years and exercising these rights will then be given pre-settled status until they have achieved those 5 years, achieved that 5 years residence in the United Kingdom, at which point then they can make the application for settlement. If, however, you have an individual who has resided in the United Kingdom for more than 5 years, and during that period they have been the primary carer of a qualifying child, then that person can apply for settled status, which is the equivalent of indefinite leave to remain. It's just a terminology coming from the European regulations is somewhat different, but pre-settled is essentially your limited leave to remain, and settled status is indefinite leave to remain. So they are. So that's the update, hot off the press today. I mean, the policy itself is quite big, but the key thing to note about this policy is that, as many of you will be aware, there were deadlines by which these applications needed to be made. And so the Home Office, accepting that this policy has only just been published today, the 13th of June, needs to acknowledge that there will be individuals who haven't already made this application. And so an individual who now wishes to rely on the Zambrano route can make an application, and the cut-off deadline will be the 25th of July 2022. So if the application is made prior to 25th of July 2022, then that individual is accepted to have a reasonable excuse for not making the application prior to the 30th of June 2021, as they were. If the individual, however, makes the application after the 25th of July 2022, then they will need to have a reasonable excuse. So if the application is made before, the Home Office will infer and accept that there was a reasonable excuse without an explanation being given. If the application is made after the 25th of July 2022, you will then need to satisfy the Home Office that there was a reasonable excuse for that delay and for that to be addressed before the application is accepted. So if you are an individual who is looking to either make an application under the Zambrano route or require some further information about Zambrano carers and applying for pre-settled or settled status, then please do seek legal advice. bear in mind that at the moment there are problems with accessing legal advice. Most solicitors are full to capacity. There are issues around that. And your deadline, although it seems quite long, is not that long. Essentially, it's 5 to 6 weeks maximum before those applications need to be prepared and submitted. And there will be a lot of people that have been waiting for this policy to try and make those applications. So do get onto that urgently if that is something that you want to benefit from, to make sure that you're not then missing the second deadline. Again, most people who are going to be making these applications will be relying on paper application forms, and there's inevitably a delay in contacting the European Resolution Centre, obtaining the relevant application form, and then having that appointment to fill it in and submit it. So you're already working against the clock. Do not delay any further. So I will leave that at that juncture. If anybody does have any further questions, feel free to please call in and ask those. It is quite a big policy, and I will admit I've not had a chance to read it all today. But I have got a good grasp of what the policy is and what it entitles people to do. If there is something more specific that I need to refer back to the policy for, then I may take your details to come back to you with regards to that. But the overview is you can make an application and you can do, and you must do so before the 25th of July 2022, unless there is an absolute reasonable excuse. And Appendix EU sets out what will be considered to be a reasonable excuse. As I say, this has been a long time in coming. Most people know about it. And so maybe I wanted to get legal advice is not going to be a reasonable excuse. The kind of things that the Home Office has looked at as reasonable excuses previously is vulnerabilities, you know, the health issues, either physical or mental health issues that have prevented individuals from making these applications. And that's where their thinking lies in respect of reasonable excuses, not just I couldn't get somebody to help me. We are going to our first break. Inshallah, when I come back, I will continue to take your calls and answer your questions. Inshallah, join me then. Assalamu alaikum wa rahmatullahi wa barakatuh. Assalamu alaikum. Welcome back to the Assalamu alaikum. Welcome back to the Free Legal Advice Show on British Muslim TV. I am your host, Riffat Hussain. We are now into the second segment of the show, and we have a brother on the line with a question. So, inshallah, I will proceed to take that call. Hello, assalamu alaikum. Hello, assalamu alaikum. Brother, can you hear me?
You clear and loud, yeah.
Yes, please go ahead. Do you have a question for me?
Question is, recently I have applied for fee waiver. I am on 10 years family route with my 4 kids.
Yes.
And query regarding the asking me the letter from my friend or family who are supporting me.
Mm-hmm.
When I write down the letter, what should I write down, or their signature as well for my family or friends who is supporting me financially?
Okay, so and did you make the application yourself, or did you have a legal representative making that application for you?
Did myself online.
You did the application yourself online. So a fee waiver application, brother, is obviously, as you know, but many of our viewers may not. It's an application where an immigration application is being made to the Home Office, and the applicant is unable to afford the associated fees. And if that individual is going to be destitute, or if they are already destitute, or there are exceptional financial circumstances, then an application can be made to the Home Office to waive either the full fee or a partial fee. And so your question, brother, is that the application has been submitted, and the Home Office has requested some additional information from you, namely letters from family and friends who are currently supporting you.
write down in the letter,
Yes.
and on these letters,
Yes.
do they require the signature of that person who?
They will do. They will do. Yes. The Home Office, as part of a fee waiver application, needs to consider your full financial circumstances, and depending on how you are financially supported, they will need evidence that. So usually, people may be supported by the council. In your case, it sounds like you're being supported by family and friends. And so what the Home Office need to look at is, where is your money coming from? Who is providing that? And more importantly, why are they not able to fund your applications? That's the question that they're trying to answer. If these individuals are happy to provide you with rent or mortgage payments, your weekly food shopping, clothing for the children, utility bills, why then are they not able to help you pay for these applications? And that's the question that the Home Office is essentially wanting to answer through these letters that they've requested. And so when your friends and family are writing these letters, that's what they're aiming to do. They're aiming to provide the Home Office with evidence of how they're supporting you and why they're unable to provide additional support which will help you meet the cost of these applications. Again, you are entitled to legal help with these matters, and that may be advisable at this stage, because they're not uncomplicated applications. There needs to be a lot of evidence, corroborating evidence, and the right evidence for the Home Office to come to that decision. But essentially what your friends need to write is what support they're providing, because the Home Office will need to make sure that the support that you currently have is exactly what you are receiving. So, for example, if you provide a letter to say, we provide this brother with, I don't know, £10 a week, and you're a family of 6, 4 children, you and your wife, then that's insufficient to meet your needs. And the Home Office will then rightly say, well, you're clearly not surviving off £10 a week. So where are you getting the rest of the support from? Where are you getting your accommodation from? So that's what you need to do. Each individual that writes this letter needs to set out who they are firstly. What's their identity? What's their status in the United Kingdom? What level of support are they providing you, and how frequently? And then do answer that question directly, why they are not willing to provide additional support to cover the fees for this application. And also you may want to add in there how long they are willing to support you as well. And be honest, don't for the sake of sending this to the Home Office say, right, we're only going to support him till the end of the month, when that's not true. If they've been supporting you for the last 7, 8, 9 years, why are they suddenly going to stop support a month after the Home Office requests a letter? So be honest. The Home Office are experiencing these kind of things. They will realise when something doesn't add up. But yeah, so signatures, contact details, because the Home Office may wish to speak to these individuals. They may want additional evidence from these individuals. How are they supporting you? What are their financial circumstances? Do they have jobs? Are they themselves in receipt of public funds? And if they are in receipt of public funds, how are they affording to give you what they are affording to give you? Unless it's a packet of pasta every 2 weeks, unless it's a bag of flour every so often, that kind of support is realistic. So again, piece it all together, get those sent off to the Home Office, and then inshallah you should hopefully get that decision that you're wanting back. Does that answer your question?
It did. And one more question.
Yes.
They asked me for 6-month bank statement.
Yes.
But the bank statement I have opened, I think, less than 6 months.
Okay.
I have opened the account. So shall I give them still the details, or?
Yes, and you will still be required to. And if the bank account's been there for less than 6 months, you can only give the details for the period that you have held that bank account. It may be worth just writing a covering letter, again explaining that you've only had this particular bank account for less than 6 months, or the period that it has been open. Do you have any other bank accounts?
I do, yeah.
Okay,
in
because
the accounts.
yeah, I mean, what the Home Office does, and this is probably why, you know, legal advice at this point is important, because you need, you know, you want somebody who's going to prepare your application and do it right the first time, rather than it being piecemeal. What the Home Office will do is they will carry out checks to see what bank accounts you and any of your family members hold. And so if you haven't provided details for all of the bank accounts, the next thing that's going to happen is the Home Office is going to write back to you and say, okay, we notice that you have another bank account. Now provide 6 months details from that bank account. And it will carry on happening. So what you need to do is take a proactive approach and say, right, okay, they want details of my finances. I have all of these bank accounts, and that includes dormant bank accounts that you may have had 20 odd years ago, you've never used after that, but they are still open and in your name. They do come up on the Home Office checks. So anything like that, you need to provide evidence for. Open bank accounts, 6 months worth of statements. If obviously you've held them for 6 months. If you haven't held them for 6 months, then, you know, provide an explanation and provide details for the period that you have, so 4 months, 5 months, whatever it might be. And then if there are any dormant bank accounts, any bank accounts that are still in your name but have nothing in them, you might want to get a letter from your bank confirming that they are dormant accounts and that there's nothing in them. They just happen to be open in your name. And again, that will speed up this process, and it will mean that you're not having to keep sending bits of information every time the Home Office realises there's something else. Does that help?
It did, thank you. And one more.
Yes.
You know, when the income coming, let's say, for example, £10 from my family scheme.
Yes.
So should I just highlight it on the bank statement, or shall I write separately, or get the bank? What should I do?
Yeah, it depends on how complex your bank statements are. I mean, if it's just a basic kind of, you know, there's £10 coming in from here or £10 coming in from there, and it's fairly obvious what's happening, and it's usually the same people, then you can just annotate your bank statement. You can just highlight it and make a note on your bank statement, because that's going to be easy enough. If you've got a more complex bank account where you've got lots of things coming in, but then lots of things going out, or, you know, lots of different people putting money in, and it's not really that clear, what you might want to do is do a breakdown. So still highlight the income and the outgoings. You might want to use 2 separate colours to highlight those so that it's obvious. And then you might want to kind of do a table of income and outgoings. So income and liabilities, and to see exactly what kind of money you've got coming in and then what you've got going out, and whether or not you've got any disposable income, any money left over that you could realistically be saving to pay for these applications. So the key with these applications is make it as easy as you can do for the Home Office to assess your circumstances. And so the easily the information is read, the well presented it is by you with the supporting evidence, the quicker the Home Office will make that decision and a decision in your favour. The more complex this is, it will take the Home Office a lot longer, and they may not necessarily read the information as correctly or in the way that you want them to, and it may then result in the fee waiver applications being rejected. And quite a lot do get rejected, so just be careful of that.
You use the word, and what did you use the word for the highlighting thing?
So in terms of highlighting, so there's two parts. So there's income and there's outgoings. So income and liabilities. So your income obviously is money that you get coming in. That may be from friends, it may be benefits, it may be other methods. And then you have liabilities. So you'll have your bills, you'll have, you know, other payments that are going out of your account. And as I say, it's always helpful to do an income and an outgoings chart for the Home Office, particularly where the income is fairly consistent and regular, to say this is what I get in, this is what I pay out, and then at the end of it I'm left with either nothing or very little. Does that help?
It's very clear. Thank you very much.
You're more than welcome. But as I say, if you are able to, do try and get the legal advice, because you don't want to be in a position where it's been rejected and you're having to start over again. Okay. Thank you, brother, for taking the time to participate in the show. If any of our viewers do have questions, please do come through. I can reassure you, if there's nothing else I can do, that what you're doing is the correct thing for you to be doing, and that you're not heading to set yourself up to fail. Inshallah, keep those questions coming through, either live into the studio or onto the WhatsApp group, and I will return after this short break to continue helping you. Inshallah, join me then. Assalamu alaikum wa rahmatullahi wa barakatuh. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I am your host, Riffat Hussain. As you saw before we went to the break, we were receiving questions and able to assist our viewers with their legal matters and to provide both guidance and reassurance. A lot of the time, individuals may think they know what they're doing, but need to have that confirmation that that is indeed the right course of action, and then some hints and tips along the way, so that they are not going to fail, or that they can deal with whatever it is that they are going through in the most efficient and prompt manner. If you have a question like our brother did before the break, then please do call through into the studio with that, and I will be able to talk you through your circumstances and provide the guidance that you need. Alternatively, please do send your question through onto our WhatsApp group. The number is also at the bottom of the screen, and I can pick that up and go through that for you. So, inshallah, moving on to some of the written messages that we've received. And again, thank you so much for taking the time to send these through. I'm always appreciative of individuals taking that time to participate in the show. We're here to help. And so it's always nice to see that people are receiving the assistance and the guidance that they are looking for, and do either come back for more, or other individuals then take advantage of that as well. So moving on to this question, is quite a lengthy one, so inshallah we'll just take the time to read it. So assalamu alaikum wa alaikum assalam wa rahmatullah. I'm on a tier 2 visa, which I initially received with my husband and son as my dependents in October 2017. We are due to apply for indefinite leave to remain this year, but my husband does not fulfill the 180 days per year criteria for being inside the UK for all the 5 years, and he is now living with me permanently in the UK since 2019 and not planning to leave. What should we do? Would he be accepted for indefinite leave to remain? Would he be accepted for indefinite leave to remain if he applies with us in October 2022? If not, how can he continue to live with us here? On what visa? And what is the process, since we all have the same expiry date? So Jazakallah khair for sending that question through. With regards to tier 2 visas and any dependents, each person applies individually for their extension, or in your case, the indefinite leave to remain. And so if your husband does not meet the requirements for indefinite leave to remain, then instead of applying for the indefinite leave to remain in October 2022, when you and your son do, he would apply for an extension of his current visa, and then meet the requirements for indefinite leave to remain. Once he's then satisfied those requirements, he can make his application for indefinite leave to remain. But if he doesn't satisfy the requirements, then no, he would not be accepted, and his application would be rejected. So my advice is he applies for an extension, he then continues to reside with you, and you make your application and your son's application for indefinite leave to remain. I hope that does answer your question. Moving on, I understand that we have another caller on the line, so inshallah we'll proceed to take this call. Hello, assalamu alaikum.
Assalamu alaikum, sister.
Alaikum assalam.
Oh, sorry, I just asked you a question. I forgot I remember now. How to annotate the bank statement? That's what I wanted to know.
How to annotate the bank statements. So
Yeah,
with regards to annotating bank statements, you can do it, I mean, it depends on what you want to do and what information you want to provide the Home Office through those. So you might want to have two separate colour highlighters and highlight the income and the outgoings. And then if it's not clear, because sometimes your statement will not say what something is, what an entry on your statement is, it may just be letters, it may just be a reference or numbers. If it's not clear what it is, then you might want to add a brief note next to it to say, for example, water bill, or for example, utility bill, you know, or clothes shopping. You know, if it just has a random entry there, you might want to be able to say what that was, you know, children's shoes or uniforms. It's just so that the Home Office understands what the entries are. But that's only, as I say, if it's quite complicated. If your statements are not that complicated and you don't want to annotate them, then there's no requirement that you do. But I find that it is helpful because it immediately channels the Home Office's attention to what it is that you're presenting in that data.
Okay, all right.
Yeah?
I understand now. Yeah, I
Perfect.
understand.
Wonderful. Thank you so much. Thank you, brother.
Thank you, Aslam.
Alaikum assalam wa rahmatullah. So again, a follow-up question there. Brother was unsure about what he needed to do. And I say that's what we're here for. If there is anything that we can clarify for you, to make sure that this journey is made that bit easier, because they're not easy, simple processes to go through. They can be quite complex, and particularly around the immigration rules and guidance. And, you know, one might say that they are deliberately confusing. I certainly know that many practitioners and certainly some judges have difficulty navigating these rules. And there was, in fact, a report not long since that confirmed that they were unduly complex rules and sets of guidance. We are aware that the immigration laws are being rewritten. So all of the previous legislation that we have, and we have a lot of it, will be combined and put into one particular piece of legislation, and that's due. That's in process now, and that's due to happen not soon. So you know that confirms how difficult these rules can be and how daunting they can be, because what often we forget is these are people's lives. These are individuals who, if, for example, somebody's immigration application is refused or they can't afford to pay to make the application, their life comes to a standstill with real, you know, life impact for that person. It impacts, you know, where a person lives, because if you're here unlawfully, you don't have the right to rent. If you are here unlawfully, you don't have the right to bank accounts. If you are here unlawfully, and as an overstayer, you don't have the right to work or to access to benefits and services. And so that individual's life does literally grind to a halt. And so there are some real consequences, dire consequences for fellow, you know, human beings. And so it's really important that where we can help, that we are able to help, so that process and that journey is made simpler and easier for those who are entitled to make those applications. So just moving on to some other questions. We have a question here about an application that was submitted for a spouse visa. The application has now been pending for 10 weeks. And the question is, how long do we have to wait? And is there anything else that we can do? So thank you again for sending that question through. At the moment, we know that entry clearance applications, these are applications made from overseas for individuals to enter the United Kingdom, at the moment are taking up to 24 weeks. That's the Home Office guidance. So it was previously up to 12 weeks, and the Home Office is now saying longer than that, so up to 24 weeks. So if you have only been waiting 10 weeks, you've probably got a little bit longer to wait Is there anything you can do at this stage? I'm afraid that there isn't. All applications are delayed. And probably there's going to be further delays in respect of those as well, because the Home Office is trying to get on top of the chaos it has caused around the Ukraine crisis and the visa system from there. So that's basically where we are in respect of those. There are delays, and these delays, again, they're delays in the United Kingdom, and they're delays for applications made overseas. So it seems to be across the board. Talking of delays, I did talk about this maybe a couple of months ago now about asylum applications and the delays. We had figures at that point that suggested that there was delays of the Home Office had 78,000 pending applications. We had some more figures last week, and unfortunately they paint an even more bleak picture. So at the moment, individuals with pending asylum protection applications, these are individuals who are fearing persecution and fearing their lives. There are 107,000 applications pending with the Home Office. And that doesn't account for the applications that have been made after that figure was compiled. And then there was a lot more on that. There are hundreds more on that as well. So I've just rounded that down. Quite a difficult circumstance at the moment with, as I say, real impact on people who are already traumatized. There aren't the services in place. Do seek that help. If you are seeking asylum, if you are trying to make an application to regularize your immigration status, then do seek the help that's available. And there are some fantastic organizations out there that can help. Your starting point might be your GP, particularly if your mental and physical health is not where it needs to be. And there's a lot of stigma within our communities, particularly around mental health. That you will not be ridiculed. You will not be judged. There are services out there designed to help people who have experienced very traumatic things that we here in this country can never imagine can happen to a fellow human being. And you do need to address that trauma, and you can address that trauma in a non-judgmental clinical environment, but you do need to seek that help, and it is out there. So please, as I say, please do. We know mental health problems can then cause physical health problems, but there are, as I say, there are services available, and do access those. If you're struggling financially, for example, because you're an overstayer and you have children, you may be able to access help from your local council. Do go out there and seek legal advice. That's what legal representatives are there for. That's what us solicitors are there for. And I know that we may look scary and it may be daunting to have to go and address these issues, but we are there to assist. And if we can't assist you, we can certainly signpost you to another organisation that can. Inshallah, we're heading to our final break for this evening. Do come back and join me after this, where I will pick up some more of your questions. And if you do have questions, send them through and I will answer them after this break. Assalamu alaikum wa rahmatullahi wa barakatuh. Assalamu alaikum and welcome back to the final segment of the Free Legal Advice Show on British Muslim TV. I am your host, Riffat Hussain. Just before we went into that break, I was taking questions, now picking up on questions that have been sent through to our WhatsApp group. Inshallah, please do keep them coming in. We are in the final segment, so if you do want it answered, do get that in because we may run out of time. If you do send a question through and I don't get around to it this evening, please accept my apologies in advance. I will retain your question until my next show. However, alternatively, you might want to have that question answered by Mr. Ilyas Bulbulia, who is here tomorrow with his Free Legal Advice show, and we'll be able to pick that up for you as well. Otherwise, as I say, I will keep the question and answer it next week on Monday from 7 p.m. Back on this channel. So next question is, if I want to get someone in the country from Pakistan, his age is roughly 28 to 30 years, what are the avenues? Is work permit possible, or student, or anything else? Thank you. I mean, it depends on why this individual is wanting to come. Are they wanting to come as a student, in which case there are the student route options available for him? Or do they want to come for work purposes? And again, we have at the moment, generous policies with regards to individuals being able to come to the United Kingdom and work. We have a well-documented labour shortage. We are recruiting talent from overseas. But it's a matter for your friend or this individual that you are wanting to bring to the United Kingdom to decide what is the purpose of them wanting to come to the United Kingdom, what are their skills and their experience for them to make the most appropriate application. So, for example, if it is a student and they are seeking to continue their studies, and bear in mind that a student has right to work in the United Kingdom as part of their student visa, although there are certain restrictions, it's not full-time, but that there is a right to work there, then they might want to apply for a student visa. Again, you need to look at what level they're coming in. Is it an undergraduate level? Is it a postgraduate level? Or is it even a foundation year? Do they need to come in to prepare them for studies in the year before they embark on an undergraduate course or a master's course? So there are various options within that category. And again, as I've already alluded, there are lots of methods in which work permits can be applied for, or certainly global talent can be brought into the UK. Depends on the individual circumstances. Your question is unfortunately quite broad. We know that there are policies that are already in place for individuals coming to the United Kingdom. There are policies that will come into place later on this year. So, for example, if your a friend or your relative is a graduate from one of the top universities, we have a route that will come into force later this year, which allows those individuals who are graduating from top universities, with really good grades to come in the United Kingdom and progress here. You may have an individual who, for example, is wanting to come and work within one of the shortage occupations. There's a list on the Home Office website that you can refer to. You may have an individual who has, for example, is an innovator or an entrepreneur who wants to come in to start up their own business, and there's those options. So, there are lots of options, but I think you kind of need to have a more tailored conversation with a legal representative once you and this friend or relative have decided exactly what their skill set is and what the purpose of them coming to the United Kingdom, apart from just coming to the United Kingdom, is, so that those categories can then be narrowed, and then you can be advised about what the requirements are and how those requirements can be met. So I hope that helps. I know it's a very general answer, but as I say, at the moment the question is too broad for me to give anything more specific. Moving on to the next question, we have, so hello, I'm applying for a UK spouse visa for my husband. He is an asylum seeker with refugee status in Europe. Would this be still okay for applying? Then yes. As long as you meet the requirements for a spouse visa, there's a lawful marriage, and the marriage was lawful in the place it took place, for example. I'm going to guess you said Europe. So if, for example, your husband is in Germany and has lawful residence in Germany, and the marriage took place in Germany, then as long as it's a valid marriage under German law, then you will then be regarded as husband and wife. And your husband is lawfully in Germany because he has a refugee status. I'm using Germany as an example. He can make the application in that country. If, for example, though, the marriage is not a legal marriage, and that would be a scenario where, for example, the marriage took place in a European country, but it was a nikah, and it's not recognised as a lawful marriage for that particular company. You're not legally married for the purposes of the immigration rules and for British law. In those circumstances, what you might want to do is apply for your husband to come here as a fiancé, and for you to then register a legal marriage in the United Kingdom, and then extend his visa or vary his visa. So you come in as a fiancé, the marriage takes place, and then he can make an application for a spouse visa in the United Kingdom. I'm not entirely sure what the purpose behind the question is. I don't know if it relates to the fact that your husband is an asylum seeker with refugee status. The two terms are not correct together. So he's either an asylum seeker, and that's a person who is seeking and waiting for protection, sort of for refugee status, or they are a refugee and they have already been granted. If he has a refugee status, he is just a refugee. He's no longer an asylum seeker. But if the purpose behind the question is that he has refugee status, would he be permitted to make that application in the European country he's residing in? Then the answer is yes, because he's lawfully resident there as a refugee, and that's not a bar to him making that application. Obviously, it would be different if he was an asylum seeker and he had no lawful status in that country, because he would then be waiting for that asylum decision. But as a refugee, yes, the application can be made. You have the two options. Is it a lawful marriage? Yes. Make the spouse application. If it's not yet a lawful marriage, then either go out and get married in that country lawfully, or invite your husband to the United Kingdom as a fiancé, have the lawful marriage here, and then apply for that visa. So I hope that answers your question. I have done previous shows on the requirements of a spouse visa, but if you do want me to cover that, then inshallah send in a follow-up question. We are in the last 4 minutes of this show, so it's unlikely that I'm going to be able to pick that up today, but inshallah I can pick that up next week for you and follow on from that if you do need me to. I have another question. It's probably going to be the final question for this evening, but again, feel free to send more through, because I will save them and pick them up next week for you. It may even be that I can get around to it depending on how in-depth this question is. Says, Salam sister, my name is, I am living in the UK for 15 years. I like to bring my sister from Pakistan. She is married and got children. I am a German national. Can I apply for a visa for her? So, walaikum assalam, brother, and thank you for sending that question through. Now, this question, again, a UK immigration question. It doesn't say, brother, what your status is. You said that you've been living here for 15 years. Do you have settled EU settled status in the United Kingdom, or permanent residence as it used to be called? I'm assuming if you've been here for 15 years, you do. And then the second part of your question is, can you invite your sister and her children to the United Kingdom? And it doesn't again say on what basis. Is it a visit visa that they're wanting to come for? Or is it, is it a visit and therefore you're applying for a visit visa to bring them here? Or is it a more permanent arrangement that you're looking for? Kind of in general terms, as a visitor, yes, your sister's married and she has children. If they do want to come and visit the United Kingdom, then you can make that application. I haven't got time, unfortunately, to go into the requirements and how that will be dealt with. If it's a more permanent arrangement that you're looking for, it's probably going to be difficult, because then what you're looking at is an adult dependent relative, plus obviously their children. And if she is married, then, why is she dependent on you? If she's leaving behind a husband in Pakistan, then why is she leaving him behind to come and be dependent on you, and why is she still not dependent on him? So there's lots of variables within that scenario. I probably will need some more clarity before I can give you the full list of answers. So do send that information through. What's your status in the United Kingdom? On what basis are you wanting to invite your sister and her children? Is it a short-term arrangement, or are you looking for something more permanent? Again, the circumstances surrounding that. And inshallah, what I'll do is I'll wait for you to send that question through, brother, and inshallah we'll pick that up next week and provide you with some further guidance. Alternatively, as I say, our brother Ilyas Bulbulia is here tomorrow. If you want, he can pick up the question if you do send the details through for him. We are approaching the final minute or so of this show this evening. So I will thank you all for participating. Thank you so much for taking the time to send your questions through, for enabling me to help you with that guidance. The show is here for that purpose. So please do take advantage, because the show will stay whilst you need us. If you no longer need us, then you don't have a show to come back to. As always, continue to send your questions through. Just because the show is finished for this evening doesn't mean that your questions will not be picked up. Those are still forwarded. They will be saved for either Mr. Bulbulia's show tomorrow or for my show next week. So feel free to send your questions in during the week. It just means that they're in there sooner, and we can then pick them up when we start our shows on the next occasion. Provide as much detail as you're able to, and inshallah continue to tune in so that we can help you. That's it for this week. Jazakallah khair. Assalamu alaikum wa rahmatullahi wa barakatuh.